Federal and state courts are systematically reinterpreting the Fourth Amendment's unreasonable search clause in favor of public safety over property privacy. By the end of this video, you will know Fourth Amendment reinterpretation and all implications. So let's get into it.
If you're a gun owner, your constitutional protections against warrantless searches and preemptive confiscations have been quietly dismantled through judicial decisions most Americans never heard of. From Halash, school safety doctrine, to Case v. Montana's emergency aid. Exception to Willie v. Brown's red flag approval, courts are establishing new constitutional principle: supremacy of right to life and public safety over property privacy. Willie v. Brown explicitly held reasonable grounds required by red flag laws equals probable cause required by Constitution, meaning states' preemptive gun confiscation authority now has full constitutional protection. Subscribe, because this systematic Fourth Amendment reinterpretation is accelerating in 2026, and understanding how courts choose public safety over privacy is the only way to protect yourself when wellness checks or neighbor complaints become justifications for warrantless searches and gun confiscations. Across multiple contexts: school safety, Halash, emergency aid, Case v. Montana, red flag laws, Willie v. Brown, immigration enforcement, courts applying same framework. When public safety conflicts with Fourth Amendment privacy, public safety wins. This is deliberate judicial philosophy responding to what courts describe as sociological phobia of armed violence. Courts believe Americans are so afraid of mass shootings that constitutional privacy protections must be flexibly interpreted to permit government preemptive action. Let me break down the pattern across cases showing Fourth Amendment erosion, what supremacy of life, safety over privacy means as judicial philosophy, how Willie v. Brown constitutionalized preemptive confiscation, what this means for gun owners right now, and how to protect yourself. Number one, the pattern across cases, Fourth Amendment systematically weakened. Halash, school safety. Courts held school administrators can conduct warrantless searches based on reasonable suspicion, lower than probable cause, when school safety at issue. Rationale: preventing school violence outweighs students' privacy. Schools can search backpacks, phones, cars without warrants. Case v. Montana, emergency aid. Supreme Court 9-0 held police can enter homes without warrants based on objectively reasonable basis, lower than probable cause, to believe someone inside seriously injured. For gun owners, wellness check, police enter, firearms observed, red flag petition filed. Willie v. Brown. Red flag approval. Federal judge upheld Maryland's red flag law allowing gun confiscation based on reasonable grounds, civil standard, 50%. Rationale: preventing gun violence through preemptive confiscation justified without criminal charges. Court held reasonable grounds satisfies Fourth Amendment despite being lower than traditional probable cause. Immigration enforcement. Courts permitting warrantless searches by immigration authorities based on administrative necessity when public safety concerns exist. Unifying pattern. Courts lowering Fourth Amendment standards from probable cause to reasonable grounds, reasonable suspicion, or objectively reasonable basis when public safety justification exists. Traditional framework required probable cause. New framework: public safety permits intrusion on lesser standards. Number two, supremacy of life, safety over privacy, the judicial philosophy. Traditional Fourth Amendment. Constitution protects right of people to be secure in persons, houses, papers, and effects against unreasonable searches and seizures. Traditional interpretation: government needs warrant supported by probable cause, 50% likelihood, to search homes or seize property. Framework prioritizes individual privacy against government intrusion. New judicial philosophy. Courts now articulating different framework. When life safety interests conflict with property privacy, life safety are supreme. Willie v. Brown. Maryland's interest in preventing gun violence and suicide is compelling, justifies temporary confiscation without criminal charges. Case v. Montana. When someone needs immediate medical help, Constitution does not require officers to stand outside. Schools can search students because preventing school shootings outweighs backpack privacy. Constitutional reinterpretation. Courts aren't saying Fourth Amendment doesn't apply. They're saying unreasonable search language must be flexibly interpreted when public safety at issue. What's unreasonable changes based on context. In traditional criminal investigation, warrantless search unreasonable without probable cause. In school safety or red flag or emergency aid context, warrantless action reasonable on lesser standards, because life safety outweighs privacy. Sociological phobia justification. Courts explicitly reference public fear of armed violence. Halash noted epidemic of school shootings creating sociological environment where enhanced search power is necessary. Willie referenced compelling interest in preventing gun tragedies. Courts say, American society so afraid of gun violence that constitutional protections must yield to preventive measures. Why this matters. If courts adopt life safety supremacy broadly, virtually any government action targeting firearms can be justified. Red flag confiscations. Life safety outweighs property rights. Warrantless searches during wellness checks. Life safety justifies emergency exception. School searches, finding guns. Life safety permits reasonable suspicion standard. Number 3, Willie v. Brown's reasonable grounds equals probable cause, constitutionalizing preemptive confiscation. Maryland's standard. Law allows gun confiscation if judge finds reasonable grounds to believe person poses danger. Civil standard. Preponderance, 50%. No criminal charges, no conviction. Temporary confiscation based on civil finding of potential future danger. Constitutional challenge. Willie and Saff argued this violates Fourth Amendment because government seizing property without traditional probable cause argued civil standard too low for depriving constitutional rights. Judge Herson's holding, court held reasonable grounds satisfies Fourth Amendment. Key language, reasonable grounds to believe person poses danger, functionally equivalent to probable cause in this context, because both ask whether sufficient facts support reasonable belief. Court reasoned, Fourth Amendment requires probable cause for criminal searches, but red flag proceedings are civil preventive measures, not criminal punishment, so civil standard constitutionally sufficient. Legal alchemy. Court transmuted reasonable grounds, civil, into constitutional equivalent of probable cause, criminal, by redefining what Fourth Amendment requires in preventive civil context. Opens door. If reasonable grounds equals probable cause for gun confiscation, states can enact broad preemptive confiscation laws using civil standards while satisfying Fourth Amendment. Preemptive confiscation constitutionalized. After Willie, states have constitutional green light to confiscate firearms before any crime committed, before any charges, based on civil findings of potential future danger. As long as law provides hearing and uses reasonable grounds or similar civil standard, Fourth Amendment satisfied. Number 4, what this means for gun owners' Fourth Amendment rights. Home less protected. If police claim emergency, wellness check, noise complaint, they can enter without warrant under case Virtue. Montana, objectively reasonable basis. Once inside lawfully, plain view doctrine permits observing firearms. Observations become red flag evidence. Property preemptively seized. Under Willie framework, firearms confiscated based on civil reasonable grounds without criminal charges. Ex parte orders permit confiscation before hearing. Must prove at subsequent hearing you're not dangerous to get property back. Children's privacy diminished. Under Halash school safety doctrine, schools can search students on reasonable suspicion if safety concern exists. Finding firearms or ammunition triggers school discipline, criminal charges, red flag proceedings against parents. Traditional protections eroded. Across contexts, courts permitting intrusions on standards lower than probable cause when public safety justification exists. Sociological phobia of armed violence justifies flexible constitutional interpretation, prioritizing prevention over privacy. Red flag laws proliferating. After Willie constitutionalized preemptive confiscation framework, more states enacting red flag laws. As of 2026, 21 states plus D.C. Each uses civil standards. Courts blessed as Fourth Amendment compliant. Immigration spillover. Same judicial philosophy appearing in immigration. Warrantless searches justified by public safety and administrative necessity. Shows life safety supremacy, not limited to guns, but applicable wherever courts perceive safety emergency. Number 5, how to protect yourself in this landscape. Document everything. If police enter under emergency exception, if school searches belongings, if red flag petition filed, document everything. Dates, times, who said what, justifications given, what observed. Crucial for challenging government action. Never consent to searches. Don't invite officers inside during wellness checks. Don't consent to school searches beyond legally required. Don't volunteer information. Once you consent, Fourth Amendment protections evaporate. Know your state's red flag law. If your state has red flag law, know who can petition, what standard applies, timeline for hearings, what evidence you can present. 21 states plus D.C. have laws. Secure firearms from plain view. If police enter lawfully under emergency exception, anything in plain view observable. Don't leave firearms, ammunition, tactical gear visible. Secure in safes, locked rooms. Avoid triggering wellness checks, heated arguments with neighbors, loud disputes, social media posts expressing distress. All can trigger wellness checks. Police arrive, claiming emergency, enter under case Vi, Montana. Observe firearms. File red flag petition. Get attorney immediately. If police entered and observed firearms, if red flag petition filed, if school search found weapons, get firearms attorney immediately. Cases move quickly. Ex parte orders within days. Full hearings 714 days. Challenge government actions. Don't assume warrantless entry or preemptive confiscation automatically legal. Attorney can challenge whether police had objectively reasonable basis, whether red flag petitioner proved reasonable grounds, whether school had reasonable suspicion. Bottom line, courts systematically reinterpreting Fourth Amendment's unreasonable search in favor of public safety over property privacy. Pattern, Hollish school safety permits searches on reasonable suspicion. Case v. Montana emergency aid permits home entries on objectively reasonable basis. Willie v. Brown, red flag permits gun confiscation on reasonable grounds. Immigration enforcement permits administrative searches. All use standards lower than traditional probable cause, all justified by public safety. Judicial philosophy, supremacy of life, safety over privacy. When life safety interests conflict with privacy, life safety wins. Fourth Amendment must be flexibly interpreted in public safety contexts. Sociological phobia of gun violence justifies constitutional reinterpretation. Willie critical, court held reasonable grounds when civil equals probable cause, constitutional, in red flag context. Constitutionalized states preemptive gun confiscation authority. Government can seize firearms before any crime, before charges, based on civil prediction of future danger. Rights eroded, homes less protected, emergency exception, property subject to preemptive seizure, red flag, children's privacy diminished, school searches, traditional Fourth Amendment protections weakened. What to do? Document everything, never consent to searches. Know your state's red flag law, secure firearms from plain view. Avoid triggering wellness checks. Get attorney immediately if targeted. Challenge government actions. Subscribe, because Fourth Amendment reinterpretation accelerating, and I'm tracking every decision eroding gun owners' constitutional protections. Next video reveals 5 constitutional challenges most likely to reverse this trend and restore Fourth Amendment protections.